The plaintiff Marieva Navierra SA, the ship owner, issued a writ on 25 June 1975 claiming against the defendant, International Boat Carrier SA, who are the charterers, unpaid hire and damage for repudiation of a charter party. On her ex parte application, Donaldson Judge grant an injunction until 17 hours on 23 June, restraining the charters from removing or disposing out of the jurisdiction monies standing to the credit of the charters account at a London bank. The ship owners appealed against Donaldson Judge refusal to extend the injunction beyond 17 hours on 23 June. The facts are set out in a judgment of Lord Denning Mr.
In my opinion, if it appears that the debt is due and owing, and there is a danger that debtor may dispose of his asset, may defeat before the judgment, the court has the jurisdiction to grant an interlocutory judgment to prevent from disposing of those assets. There is money in the Bank of London which stands in the name of these charterers. They may at any time dispose of it and remove it out of this country. I think this court ought to grant injunction to restrain the charterers from disposing of this money now in the Bank of London until the trial or judgment of this action. If the charterers has grievance about it, when they hear of it, they can apply to discharge it. But meanwhile, the ship owner should be protected also. It is just right that this court shall grant injunction. I would therefore continue injunction.
I agree that this injunction should be extended until judgment in the action or until the further order. The application to this court is made ex parte and is designated by the fact that the learned judge, Donaldson Judge, understandingly in the circumstances refused to extend the jurisdiction beyond 17 hours this afternoon. Though the admirable argument to which we have listened puts the case very fairly both for against continuing the injunction, the fact remains that we have only heard argument from one side, and I do not think it will be right to express any opinion as to what the result would be were this matter hereafter to be argued fully. But as at present advised, it seems reasonably clear, first, that this court has jurisdiction to continue this injunction, and secondly, that the difficult question is whether, on the present fact, this court ought at this stage to continue its judgment until further order. Donaldson Judge, in his judgment of which we have a full note, has asked a number of other questions of this court which at present charters were represented. It will no doubt be said on their behalf that the decision of this court in Lister and Co. versus Stop preclude this court, not as a matter of jurisdiction.
I agree. In my judgment, the charterers here have a very strong case on the merits. We have not heard any argument from the other side because it is an ex parte application. In these circumstances, I would reserve my own views until I have heard argument from the other side, if any such argument is put forward. But in the absence of any such argument, in my view, this injunction should be continued. Thank you.
The court will grant injunction to Marieva Navierra SA. Marieva injunction. Marieva injunction is a court order which effectively frees assets of the defendant from being dissipated pending the outcome of completion of a legal action before the court. This injunction is particularly effective over liquid assets such as money held in bank or financial institution. A bank or financial institution being made aware of a Marieva injunction is a duty bound to freeze or suspend the use of the defendant bank account. This type of injunction originated out from the English Court of Appeal case called Marieva Navierra SA against International Bulgaris SA in 1980s.
There are 3 requirements to be fulfilled in order to obtain a Marieva order. There exists a serious question to be tried. The first one is the plaintiff must show that he or she has a good arguable case. To show a good and arguable case, the plaintiff merely needs to show a case which is small than being barely capable of serious argument, but not necessarily one that the judge believes has got more than 50% chance of success. If a plaintiff has already successfully obtained judgment, he or she only needs to show that there is a risk of disposal of assets. In the case of post-judgmental application for a Marieva injunction, the application will not be allowed if the plaintiff has not shown any attempt and or effort to enforce the judgment which he or she has successfully obtained. The second requirement is the defendant must have access within the jurisdiction. It is axiomatic that in order for Marieva injunction to set in, the plaintiff must first demonstrate to the satisfaction of the court that the defendant has access within the jurisdiction to which the said following the said freezing injunction can latch on to. In most cases, the plaintiff would readily be in possession of information pertaining to the defendant's assets prior to the filing of Marieva injunction. The third requirement is there must be a risk of dissipation of the defendant's asset. The third and perhaps most crucial element that the plaintiff must satisfy the court on is that there is a real risk or danger that defendant's asset may be dissipated before judgment can be obtained. An important question that a study of the jurisprudence of the Marieva injunction raises is how does one determine real risk dissipation of asset? The courts have taken divergent view on this, and it is safe to say that there is no clear answer in this regard. One view is that some concrete evidence to show that the defendant intend to evade the consequence of an adverse order by removing his or her asset has to provide it. Then there are a judgment that state that merely showing a risk of disposal of asset which has the effect of frustrating the plaintiff in his or her attempt to recover the fruits of a judgment he or she is likely to obtain against the defendant would be sufficient. Some courts have gone further and stated the risk of dissipation of asset can be gauged from the nature of allegation and past behavior of the defendants, including the defendant's dishonest conduct, if any, prior to commencement of the suit.
Under Rules of Court 2012, the application for granting Marieva injunction is subjected to Order 29, Rule Number 2, where such application of injunction may be made where a notice of application supported by an affidavit and where the case is of urgency may make as party. This rule is used together with Order 29, Rule 2A, Subsection A of Rules of Court 2012, which provides the affidavit in support of an application of an injunction made ex parte must contain clear and concise statements of the facts giving rise to the claim, the facts giving rise to the application, the facts relied on to justify the application ex parte, any answer by the other party to a claim, any facts which the court would not grant the application ex parte, any similar application made to another judge, and the precise relief sought.
Under Specific Relief Act 1950, there are a few sections that define the scope of temporary and perpetual injunction under Section 51 SRA 1950. Section 52 of SRA 1950 lays down the circumstances in which perpetual injunctions may be granted by the court. Section 53 of the Specific Relief Act lays down the circumstance in which the court will grant mandatory injunctions, and Section 54 SRA 1950 stated that the circumstances in which the granting of injunction may be refused by the court.